Hello, it's Phillip Taylor speaking from Richmond Green Chambers in London. Now, this afternoon I'm looking at a book which has come to us from Derek Roebuck. He's written a number of books on mediation and arbitration which we've found very interesting, and we've reviewed a number of them. They've been published by HOLO books as part of the arbitration press in Oxford. And this particular book we're looking at, which is called Mediation and Arbitration in the Middle Ages, England between 1154 and 1558, written, as I say, by Derek Roebuck, has been sponsored by Arthur Marriott, Queen's Counsel, 12 Gray's Inn Square. It's an excellent book, and I've been delighted to read it, and as has my wife Elizabeth. We've given a review title for the appreciation we've produced, How They Mediated in the Middle Ages, a few lessons for our times. Now, that's really where we're coming from. I'll talk about the review in a minute, but the reason I say that is because mediation's been with us a long time. Let's look at the book first of all. There's the front cover, very much a house style. There's the spine, then there's the back of the book. Very much a house style that Derek has produced. There's a nice picture of Derek there, some detail about him, and then on the back you've got other books in the series from HOLO books. Now, let's start at the back of the book. It runs to 400 odd pages. There's a very useful index at the back. And again, after the index, you've got a very detailed bibliography. Derek is nothing if he's not meticulous, and he's done a huge amount of work in this area. And I think it's very, very useful to have all of this, both from an historic point of view and also from a legal point of view. Again, he's got a chronology, which I always find extremely helpful because I do forget things and dates. It's like everything else. So it's very nice to have that information at your fingertips. Then you've got a glossary of terms. Again, very important. Anyone who's studied a little bit of English legal history will know land law being a particularly good example of some of the words that we need to know about going back all those centuries. Then you've got the actual wording, the actual text itself here. You've got a certain amount of footnoting, all of which links into the bibliography at the back. Again, you've got a little bit, some subtitles as well. Town and Gown, Oxford, there we go. Nice little bit of talk there about Oxford all those years ago, 1209 or 1209. A long time ago. Now let's go to the front of the book. There's some of the books Derek has written, and there's the front page itself. And this is dedicated to Lord Newburgh, a very nice dedication. I always like to mention those. Then this is a formal settlement of a dispute, which is there. You've actually got a picture on the front page, actual front of the book, and then there's one in there. And then you've got the parts that make up the contents of the book there. There's a lot of detail here, part 3, and you go through, you see the various areas concerned, the cities involved, Oxford getting a special mention, the Jewish community getting a special mention too, women, the church, and then part 5, the law itself, an introduction, then conclusions in chapter 19, and then you go straight from there into a little preface, which is very useful to read. Dated December 2012. So there's a few years ago since Derek wrote this now, but it's a wonderful book, and I've been very pleased to read it and review it. There's the part 1 for background. Then we kick off with some quotes and an introduction. So, as I say, I found it very easy to read, apart from anything else. I mean, one of the problems with some of these early English history books is that they can get boring rather quickly. This one isn't. It's very well written. And it makes the subject come alive. You've got to be, like I am, an enthusiast for both the law, English legal history, and history itself. Because what we get here, and the point about our review is, actually what we've got here, is there something we can learn from the past for our own experiences today? Now, I'm recording this review after the general election in May 2015. We've got a new, possibly 5-year government, quite a lot of reforms taking place, and I'm certainly quite convinced within the legal area that I'm involved in that we will see continued expansion of mediation, mainly because of costs involved and lots of other things, but we have the lessons of the past to learn from, and I think it's worth reading this book just for that. This is what we say, as the title indicates, this is one of Derek Roebuck's scholarly and invariably engaging examinations of the ways and means by which disputes were settled in times past. His earliest work dealt with ancient Greece. This one, the fourth in the series, concerns dispute resolution in England during the Middle Ages from 1154 to 1558, the beginning of Elizabeth I. So we're looking at Henry II to Elizabeth I. The dates are significant, as I say. 1154 marked the start of Henry II's reign and the tentative beginnings of the English common law, circuits and all the other things from the Glanville document and all the other things that started to take place with the creation of proper ways of coming up with some form of reasonable justice. And of course the development of what we now know as and have as established concept, the common law and cases. And then obviously it runs up to the beginning of Elizabeth I's reign, and that was a new period again in the development of the English legal system as it was continuing to emerge. And do remember the linguistic issues, because Henry VIII was the one person who effectively set modern English as we know it today on its first tentative steps. Before that you had other languages that were involved, and that's why it gets quite difficult to follow, frankly. But I think Derek really brings the subject alive with this excellent book. Remarkably, although perhaps not unexpectedly then, a thorough and detailed survey like this of dispute resolution during the medieval period, encompassing just about every aspect of human activity and human concerns, is not something we've really seen a lot of, and so I really welcome this. Arbitration as a focus of study, therefore, will invariably and inevitably touch upon both legal, political and social history, and of course literary history as well, and that's what we found interesting about this book. For example, would you believe the first known usage of the words mediation and arbitration turned up in the works of Geoffrey Chaucer. Arbitration appears first in Chaucer's Melibæus and in the Canterbury Tales, the Man of Law's Tale, what a surprise there, showing that the lawyer tells the story of the Sultan of Syria wishing to marry a Christian princess. What need is there for disputation, or even for the Pope's own mediation, etc., etc. So you've got some idea of where we're coming from. And the length of time. Remember, Chaucer died in 1400 and we're now in 2015, long time ago. So you see how over the centuries things have built up effectively. But it's with us and it will remain with us, this concept of mediation and this concept of arbitration, and we've got to make the best of it. And that's what I tell quite a lot of clients, especially when money can be such a big issue. And is it really in their best interests sometimes to have their day in court when we might be able to solve it without having too much blood, if you like, splattered around the courtroom? Now, note too, and remember that's only an analogy, I've just given you an illustrative analogy. Note too that this is not merely a literary curiosity, this book. Chaucer, who was a diplomat by profession, he studied law, possibly at Lincoln's Inn. I think probably that's right, I'm not quite sure, but it looks like he did. And was also possibly involved in negotiations that brought about the Peace of Calais in 1360. You've got to be a bit careful with Chaucer. Obviously his works have survived and he was very well thought of during his lifetime. But be just a little bit cautious of some aspects of it. But remember, dispute resolution was evidently just one of his areas of expertise. And we're thankful we've got something that gives us some idea of how they went about their business in those days. Of course, this is only one example of the wealth of insight and anecdote contained in the book, published as I've indicated by HOLO Books. It reveals the Middle Ages as a vibrant and sophisticated era in which dispute settlement ideally emanated from within the communities and generally depended on arriving at an agreement between the disputatious parties rather than having a decision imposed on them by a superior authority. And that, of course, is the key to what we're even doing today. So it hasn't really changed much. And we do actually, if we can, want the warring parties to go away feeling satisfied so they don't come back again. And of course, the one point that I would make about law is that we don't want the courts over heavily involved in what is, in many cases, in terms of commercial deals, something that the courts really should have a very small place in, because we should be able to get about our business without having to constantly litigate. Now, having said all of that, it would seem that just about every community in medieval life would or could be involved in settling disputes. Good concept. Following a description of the historical setting and the legal system, the book then examines the dispute settlement role of such groupings as cities and boroughs, mentioned Oxford for instance, lords and councils, women, the various Jewish communities, universities, the church, and a lot more. And as I said, women also rate a separate chapter, which I think is very valuable, in which there's a section on women as arbitrators. Very important role for them to obviously play, notwithstanding the historic issues that we've had with the relationship between men and women over the centuries and the decades. Women performed exactly the same roles as men when the social conditions allowed, but no surprise here, they had to be of high rank. I think that's inevitable, unfortunately, whatever you say. However, the important thing is they had the same role, and that is, I think, an important point to make, because my view, like many other people's, is I don't think of people as men or women. I think of them as the person I'm dealing with when it comes to a dispute. So if you take that tag off immediately, you do reasonably well from it. Now, from land ownership to serious felonies, an amazingly wide range of mediation and arbitration matters are discussed in this important book. But you don't have to be a lawyer, a mediator or an arbitrator to enjoy it, because in our view, with his careful and copious use of original sources, Derek Roebuck builds a picture of the medieval period that will certainly entrance history devotees keen to enhance their understanding of what is a particularly fascinating era. And I'd like to thank him very much indeed. These various books that he's produced are particularly interesting to both the historian and the lawyer. And when you have a love of both subjects, as I certainly do, I've found them great fun to read and I shall treasure them. They've certainly been very interesting, and they're books you can go back to and have another look at. I think they're also very helpful for anybody involved in the mediation process. That's from the advisors and the lawyers down to the people actually doing it, to the clients themselves. So thank you, Derek and HOLO Books, for an excellent series. Bye-bye.